Our next speaker, moving right along, is Bevan Wharton. Bevan is a counsel with the Law Practice Management Division of the Department of Justice. She provides legal and policy advice as well as training regarding all aspects of dispute resolution. She also teaches part-time at the University of Ottawa. Everybody, please give a warm welcome to Bevan Wharton.
So the title of my presentation is, So Go Ahead and Say You're Sorry, But. And we're going to talk a little bit about the limits of apology laws and apologies in general within the legal context. So as Don has already announced, I am from Ottawa, where I work with a small center of expertise on dispute resolution. But I am particularly delighted to be in Alberta because I am from Alberta, so this is home, and today is my birthday. So what a lovely day to be here on my birthday, speaking about one of the topics that I'm most passionate about, and my father has also come here as well. So I am feeling particularly thrilled. But I only have 10 minutes to go through the course that I normally teach in 2 to 3 hours, so I'll get started. So, talking about variations of apologies, let's just start with that. What are the types of apologies? And I've separated them out into 4 broad categories. I'm sorry, I'm at fault. There's some acceptance of responsibility. I'm sorry, and there's an expression of regret. I'm sorry, and there's an expression of sympathy. And lastly, I'm sorry, but not really, the ubiquitous non-apology, which includes the words I'm sorry, but perhaps not the sentiment. How are these apologies treated in Canadian common law? Well, at the moment, there is no Canadian case law that clearly states that an apology is evidence of liability. That being said, there are good reasons why your client should apologize or why you might advise your client to apologize. It can be a mitigating factor, particularly for those of you who are working in the areas of labor or defamation law when you're trying to mitigate both discipline and damages. But amongst those mitigating factors, time it right. Do not make the apology on the date of the hearing. As early as possible is preferable if you want it to be a mitigating factor. Also, there's the sincerity of the apology, which is usually judged by the adjudicator, so it's based on a subjective analysis. The nature of the apology. Is it a full apology? Is it an expression of regret? Is it an expression of sympathy? Is it a non-apology? And when I was going through my notes with some of my colleagues, they thought this was one of the most important points. Whether the apology is freely made. Has someone ordered you to apologize? All of these can be important factors as mitigating factors when someone apologizes and the court is considering this. Note that courts and tribunals are reluctant to ever order an apology, and this applies to both private parties and to governments. And there are a number of human rights tribunal decisions in many jurisdictions that talk about whether or not apologies should be ordered, and generally the accepted principle is that it will not be. So, codification of what is currently the common law position, apology laws in Canada. Since 2006, 8 provinces and 2 territories have adopted apology laws. And what these do is it codifies the idea that making an apology is not evidence of liability. So most of these laws are based on the Uniform Law Conference of Canada Model Law on Apologies. And what usually happens is there is an amendment to the Provincial Evidence Act to make it clear that an apology is not evidence of liability. What are some of the key provisions of the Uniform Law Conference of Canada Model Apology Law? The most important one is that it is broad in scope and applies to all types of civil disputes. The exception to this is in Prince Edward Island, where it applies to matters only in the healthcare field. It does not apply to criminal matters. It also applies only before a dispute resolution process and not after, and of course not during. It applies to all persons, natural and corporate. It does not limit contracts of insurance. And again, there is no obligation to render an apology as a result of the apology laws, but rather it protects apologies that are given. Also important to note, it only applies to the jurisdiction in which the apology is given. If you are in a jurisdiction without an apology law, then your apology is arguably not protected, but again, see my point that there's no conclusive common law evidence that it would be evidence of liability. So how have the Apology Acts been treated by the courts? Initially, Apology Acts were generally acknowledged with a short statement saying, this Apology Act applies, therefore it cannot be used as evidence of liability. But there have been a number of decisions since, I would say, about 2010 that have really limited how the Apology Acts are treated. So in the past 3 years, I would say that there's been more case law on apologies, all types of apologies, than there has been in the past decade. And 3 of the decisions I've summarized for you. The 2 that I find the most interesting, an apology issued before the Apology Act was adopted can be admitted as evidence, but it didn't go so far as to say as evidence of liability. And for those of you who read Lawyers Weekly, you may have read the summary of the Sime decision that came out of the Ontario court that says that apologies that are contained in pleadings must be struck. However, the court says that someone may still apologize as part of their testimony, although, as I've said before, that may be too little, too late. So, as I said at the outset of the presentation, go ahead and say your story, but remember that Apology Acts protect only apologies. They do not protect statements that are similar to apologies. They protect apologies. A change in a workplace schedule is not an apology. It also it protects the apology and not an accompanying factual statement. If your client presents you with a 2-page letter detailing all of the reasons that they are sorry, including a number of factual statements that are not known to the other side, please tell them to tear it up, as that was a situation in a case called Robinson and Craig, and actually an Alberta decision from 2010, and one of the cases that clearly states that apologies are protected and not a factual admission. This does not mean that you cannot include a factual admission in your apology. It just means that it will not be protected by the Apology Act. And so carefully consider whether or not the factual admission would be something that would already be known to the other side. For that, I would refer everyone back to the Maple Leaf apologies, one of the most successful apologies after a fairly devastating PR crisis for the Maple Leaf Foods after the listeriosis issues. Immediately, they issued apologies. The president issued an apology, made a number of factual admissions, but none of the factual admissions were not known to the public already. So carefully consider any factual statement that will accompany an apology. So here are some practical tips to leave you with when advising your clients or making an apology yourself. Time it right. Do it early. Do it as early as possible. Do not do it after a dispute resolution process and expect it to be considered as protected by the Apology Act. And earlier rather than later will mean that it has given greater weight as a mitigating factor. Phrase it right. Remember that both an expression of regret as well as an admission of fault are protected by Apology Acts. Statements that go beyond this, that are factual admissions, are not protected by an Apology Act. Carefully consider whether or not this factual admission will lead to greater liability. And lastly, deliver it right. It goes without saying that an apology that is issued that is not sincere or not freely given is not going to be given much weight by the other side or, in fact, by any adjudicator. So carefully consider your apologies. Do please consider them as an important part of legal advice that you provide to your clients, especially in the area of dispute resolution. And if I have gone over my time, I'm very sorry, Dawn. I had that all set up, so I'm sorry I had to say it. It is very sincere, even though rehearsed. And I will pass on my time to the next speaker.
Thank you very much, Evan. I don't want you to run off just quite yet. I want to know, just kind of taking a look, well, is there talk about adopting apology law in Quebec?
Yes, actually, there's been a number of editorials in the past couple of weeks where they've been talking about including an apology act in the new civil code of civil procedure, which goes into effect in 2016. So we could be looking at another jurisdiction that adopts an apology act in the near future.
Fantastic. Are there any other questions? We have a question over here.
Can you answer quickly, why is it that an apology following a dispute resolution process is not covered by the Apology Act?
So just to repeat, so an apology following the dispute resolution, why it's not covered by the Apology Act?
The short answer is because the model law says it to be so. But I believe it's to encourage parties to apologize earlier and before a dispute resolution process rather than afterwards. And so it's a question about when the apology is given. I believe it had to do with the idea of, for example, in a car accident where if someone says, "I'm sorry," right away, that would be protected at the time of the bad issue, not as evidence of liability, but rather as something, well, as I said, if you say you're sorry, it just means you're Canadian. But in this case, in a car accident context, if someone says they're sorry, usually it's not necessarily an admission of liability, but rather they're sorry that the accident took place, not an admission of fault.
Okay. Thank you very, very much, Bevan.